Well, as I mentioned, Jane, and you heard her dismiss Gary Judd KC when I said that she wouldn't debate, and I was open with you about that. And she said, "Oh, because I think I could have a much better conversation with you, Sean." But I said I'd give him a right of reply because he was prepared to debate her, but she wouldn't. So Gary Judd joins us again now. Gary, welcome back to the program. This is getting to be a regular thing. What did you think of what Jane Kelsey had to say?
Well, I think she really is failing to engage in the sort of rigorous analysis which such a serious subject requires. I mean, she, like others, parrots this idea that Tikanga is first law, and that is the only reason they seem to be able to advance for asserting that people should be made or compulsorily required to study it. Now, in fact, if you're going to approach the issue in a proper reasoning way, you've got to ask first, what is law? And once you've worked that out, then you have to say, well, if that's what law is, does Tikanga fit within it? And I've written 2 articles specifically on that subject in which I have explained why Tikanga is not law. And Vanessa, who phoned in, really hit the nail on the head when she pointed out that what we are talking about here are particular cultural matters and not law. And I found her comments interesting because I have been contacted by a person who is also an older student who's studying law at Waikato, and she is actually appalled at the way in which they are being taught about the law and the connection with Tikanga. Yeah. So apparently they are being told, according to her, that there is Tikanga, which was first law, and then there was Pakeha law, which is not really law at all, and that now
it's just a tool of colonialism, Gary.
Yeah, that's right, exactly. And that now this is the kicker, really. Now we are asserting Tikanga again as New Zealand's law. So that according to the person who contacted me, is what's happening at the moment.
Gary, there was something that Jane mentioned that I wanted to clear up with you, and we had an interesting call from John, who was a lawyer, just before the news at 9 o'clock. This Gavin Ellis case, right? Or Peter Ellis case. Peter Ellis case. Sorry, Gavin Ellis. Peter Ellis, wrongfully convicted of paedophilia, and a case to clear his name post his death, right? And suddenly this is being held up, this case, as why Tikanga law is applicable in New Zealand. John said to me it wasn't the primary reason that's been misinterpreted. Could you just explain in layman's term what the hell all this is about and what a Pākehā pedophile or alleged pedophile has to do with Tikanga Māori?
Yeah, well, the point which your first caller, Tom, made was that Jane Kelsey was wrong when she said that Peter Ellis's mana would not have been able to be vindicated were it not for Tikanga. Now that, in fact, is, as Tom said, quite untrue. Only 2 of the 5 judges took Tikanga into account in deciding that
minority report
continue. Yeah. Even Justice Glazebrook, who waxed lyrical about Tikanga being first law and so forth, at the end of the day, she did not find it necessary to take Tikanga into account when in deciding that Ellis's estate should have the right to continue the appeal. So Tom was absolutely correct about the Ellis case. Now, the point that John was making just before the news was that really the more significant case is the Smith case, where in fact the Supreme Court did appear to actually apply Tikanga in their decision that his case against the alleged climate change polluters should be able to continue. And what John says is quite correct. And that is a specific issue which, as I think Stephen Franks might have said to you yesterday, that Parliament should actually address by passing a law saying that, overruling the Smith decision.
Yeah.
So that's right. And I think the other point that I think is probably worth making, and it picks up from a text that you read out about pointing out that tikanga is based on oral traditions. It's not Maori. In fact, Jane Kelsey said that.
Yeah.
The point is, if I want to know, if I have a problem, if somebody comes to me because they want legal advice, I'm able to give that advice by going to
the law books. Yes,
or to
and
the
precedent
decisions
in cases and decisions. Yeah.
Exactly. Now, I can't do that with Tikanga because there isn't anything written down. And the other point about it is about it being oral tradition. I can't remember which one of your callers made the point that there is actually no consistency between different Maori groups.
And it's subject to interpretation. And at the risk of sounding racist, the way you find out what tikanga is, you go and give someone a backhander and they'll tell you what you want to know.
Well, I won't comment on that, but I had another a retired barrister contact me to tell me that she had actually, the large part of her work as a lawyer was in fact assisting Maori groups to resolve issues between them. And the point here is that according to the tikanga is supposed to be the right Maori way of doing things. Now, the problem is that each group of Maori may have a different right way of doing things. And that's why this barrister had to be involved in trying to sort things out. And if you look at the situation up in the north with the Ngāpuhi claims, part of the main reason why those claims have not been settled is because the various hapu up in the north can't actually agree between themselves about what they want. And you've had various ministers of treaty settlements sort of hold their hands up in the air and say, how on earth can I settle with these people when they can't actually agree amongst themselves? And that really, illustrates so clearly, I think, why tikanga can't possibly be considered as law. Law has to be general. It has to be universal throughout the territory.